Good morning everyone, especially to ma'am. My name is Gerhard Decano and I'll be reporting my part title 12 Close Corporation. So I'll be starting in section 95, so let's start. Section 95, Definition and Applicability of Title. A close corporation within the meaning of this code is one whose articles of incorporation provides that all corporations issued stock of all classes exclusive of treasury shares shall be held record by not more than specified numbers of persons, not exceeding 20. So, it's stated here no na it is important to keep record of the issued stocks of all classes, especially to not more than a specified number of persons not exceeding 20. So that's all. Next, all the issued stock of all classes shall be subject to one or more specified restriction on transfers permitted by this title. So kabalo naman tayo ni tanan, di ba, nga ang almost all of the classes of stock medyo na sila yung mga restriction on transfer permitted, kay kung wala di dali-dali lang kayo sama transfer, di ba? So ang next one is C. The corporation shall not list in any stock exchange to make any public offering of its stocks to any class. So as a closed corporation, dili ta pwede magbuhat og public offering, because a corporation shall not be deemed a closed corporation when at least 2/3 of its voting stock or voting right is owned or controlled by another corporation which is not closed corporation. So dili na ta mahimog closed corporation kung 2/3 sa voting stock or voting right is owned by another company that is not a closed corporation. So dili na ta mahimog closed corporation within the meaning of this code. So next, any corporation may be incorporated as closed corporation except, so mo ni mga exempted, no, na jud mga company and businesses nga dili ma-consider og closed corporation. So example is mining or oil companies, stocks exchange, banks, insurance companies, public utilities, educational institution, and corporations declared to vest with the public increase in accordance with the provision of this code. So mo na mga kind of businesses and companies that is exempted to be a closed corporation. So the next one is the provision of this title shall govern closed corporation, provide that other titles in this code shall apply suppletorily except as otherwise provided under this title. So I stated already there that is the provision is title shall govern by closed corporation. So that's all for section 95. Let's move on to 96. Articles of incorporation. The article of incorporation of a closed corporation may provide for a classified of shares of rights, a qualifications for owning, of holding the same, and restriction of their transfers subject to provision of the following sections. Next, a classification of directions into one or more classes, each of whom may be voted for and elected solely by a particular class of stocks. And last one is greater quorum or voting requirement is meeting of stockholders or directors shall those provided in this code. So kaning mga stated kaning tulo sa babaw nga nag-state na siya that this article is provide that the business of this corporation shall be managed by the stockholder. So instead of board of directors, ang stockholder mo mag-manage ani nga business. So so long as this provision continue, walay meeting, there's no meeting of stockholder need to call to elect directors. So walay mga meeting, siyempre, di ba? Sila na may mag-manage, so di na sila kailangan mag-meet kinsa i-elect para may mag directors. So the next one is that if the context clearly requires otherwise, kung naay context nga nag-required nga kailangan jud og director, so automatically ang stockholder may mo na siya directors, o ang mga ang stockholder subject siya to all liabilities of a director. So automatically ang mga liabilities of the directors, automatically ang unsa na mo cover ana ang stockholder, kay wala man sila yung mga directors. So muna akong pagsabot aning article sa 96. So that's all for section 96. Let's move on to article 97. Article 97. Section 97, impose two condition of validity of restriction on the rights to transfer shares. So na ito impose validity of restriction on the right to transfer shares, namely, so makita na to dre. First one is restriction on the rights to transfer share must appear in the article corporation in the bylaws as well as the certificate of stocks. Otherwise, the same shall not be binding on any purchaser in good faith. So first, kung gusto mo palit og unsa og shares, dapat naa siya sa article of incorporation in the bylaws. Kung wala sila na, so dili ansa ka ng dili maka-issue ang purchaser in good faith. So ang kailangan is incorporation in the bylaws. Kailangan sila in bylaws as well as the certificate of stocks. So kailangan nila na para ma-bind any purchaser in good faith. So the next one is there shall not be more onerous than granting the existing stockholder or the corporation the right of first refusal or option to purchase the share of these transferring stockholders with such reasonable terms, condition, or per period stated. Thus, a restriction fixing the purchase price very much below the fair market value of shares may be invalid if the existing stockholder or the corporation fails to exercise the option to purchase within the period stated. The transferring stockholder may sell in the shares to any third person. So, based on my understanding, this section tells us about based on my understanding that there's a period of time to purchase the shares. As what I have read in the present policy of Security and Exchange Commission is to limit a period of 1 month which is deemed sufficient for the stockholder or for the corporation to signify their desire to buy the shares of stock being offered for sales by any stockholder. So there's a period of time where you can buy you can purchase the shares. So as it stated here that if you're not exercise the option to purchase, so sample mahurot ng 1 month, di na mo makapalit og unsa katong mga stocks. So ang stockholder may sell their shares to any person. So mo to siya mabaligya na sa lain sa third person ang mga shares kung wala na issued within 1 month of period of purchasing the shares. So that's all for my report.
Good day. For the continuation of Title 12 Close Corporations Republic Act number 11232, I'm going to discuss sections 98, 99, and 100. In section 98, effects of issuance or transfer of stock in breach of qualifying conditions. If a stock of a closed corporation is issued or transferred to any person who is not eligible to be a holder thereof under any provision of the Articles of Incorporation, and if the certificate for such stock linagay naman yung mga qualifications of the persons entitled to be holders of record thereof, such person is conclusively presumed na alam niya na hindi siya eligible to be a stockholder kasi nga nakalagay naman na dun sa Articles of Incorporation yung mga qualifications. Yun, so hindi siya applicable. And subsection B, if the Articles of Incorporation of a closed corporation states the number of persons not exceeding 20, the persons to whom such stock is issued or transferred is conclusively presumed to have notice of this fact. Halimbawa, linagay lang ni Articles of Incorporation na dapat yung number ng entitled to be a stockholders ay dapat di mag-exceed ng 20. Pero ikaw, pang 21 ka. So, it is conclusively presumed na alam mo na hindi siya applicable kasi nakalagay nga doon sa Articles of Incorporation na dapat di mag-exceed ng 20. So, pang 21 ka So, yun, hindi siya applicable. And, subsection C, if a stock certificate of a closed corporation conspicuously shows a restriction on transfer of the corporation stock, and the transferee acquires the stock in violation of such restriction, the transferee is conclusively presumed to have notice of the fact that the stock was acquired in violation of the restriction. So, it is conclusively presumed pa rin na alam niya na yung ginawa niya ay violation of such restriction na linagay sa Articles of Incorporation kasi yung mga restriction on transfer of the corporation stock ay nakalagay naman dun sa Articles of Incorporation. Therefore, it is conclusively presumed nga na alam mo kasi nga nakalagay na dun. Pero inacquire mo pa rin. So hindi siya applicable. And in subsection D, whenever a person to whom stock of a closed corporation has been issued or transferred has or is conclusively presumed under the section to have notice of, number 1, yung qualification. Hindi ka eligible to be a stockholders kasi unfortunately hindi ka pasado sa mga qualifications. Halimbawa yung corporation na yan is para lang sa mga Aquinos. Pero ikaw, De La Cruz ka. So, hindi ka qualified. So, hindi siya pwede. And yung number 2, number of persons. So, yun nga sa subsection B, halimbawa, sinet lang na dapat di mag-exceed sa 20 yung entitled to be a stockholders, pero ikaw pang 21 ka. So, hindi siya applicable. And yung 3, restriction. That the transfer violates a restriction on transfer of stock. So, therefore, the corporation, sabi sa subsection D, may at its option refuse to register the transfer in the name of the transferee. And in subsection E, the provisions of subsection D shall not be applicable. So ano nga yung provision ng subsection D na sabi niya yung above subsections, which are subsections A, B, and C, ay hindi siya applicable. Pero may exemption si subsection E. Sabi niya applicable daw yun if it has been consented to by all the stockholders of the closed corporation, or if the closed corporation has amended its articles of incorporation in accordance with this title. Yun, halimbawa, sa subsection B, sabi ni subsection D na hindi daw siya applicable. Kasi halimbawa nga, nag-set si articles of incorporation na dapat di mag-exceed sa 20 yung entitled to be a stockholders, pero ikaw pang 21 ka. So, hindi siya applicable. Sabi ni D, sabi ni E, applicable siya if it has been consented to by all the stockholders daw. Pumayag lahat, yung mga stockholders, or yung closed corporation has amended its articles of incorporation. So, yun. Subsection F, the term transfer as used in this section is not limited to a transfer for value. And letter G, the provisions of this section shall not impair any right which the transferee may have to either rescind, transfer, or recover the stock under any express or implied warranty. So, yun nga, halimbawa sa case ng subsection D, sabi niya yung subsections A, B, and C ay hindi siya applicable. Therefore, the corporation may, at its option, refuse to register the transfer in the name of the transferee. So, anong mangyayari? Sa subsection D, sabi niya, the transferee may have to either rescind the transfer or recover the stock under any express or implied warranty. O pwede mo ring i-end. I don't know kung tama ba yung word na end. Basta yung other synonyms yan. Pwede mong i-end yung contracts of sale mo dun sa corporation na pinagbilhan mo ng stocks sana, pero hindi naman i-register sa'yo yung transfer kasi nga breach yung pagkaka-acquire mo nun. So, pwede mong i-either rescind the transfer or pwede mong ma-recover yung stock under any express or implied warranty. So, section 99, agreements by stockholders. Agreements duly signed and executed by and among all stockholders before the formation and organization of a closed corporation shall survive the incorporation and shall continue to be valid and binding between such stockholders. Yun, yung mga provisions, agreements na nangyari before the corporation ay valid pa din if such agreements are consistent pa rin with the articles of incorporation, irrespective of where the provision of such agreements are contained, except those required by this title to be embodied in the said articles of incorporation. And letter B, a written agreement signed by two or more stockholders may provide that in exercising any voting right, the shares held by them shall be voted as provided or as agreed or in accordance with a procedure agreed upon by them. Halimbawa, yung mga stockholders mag-discuss sila na ano ba yung voting right natin. Then yung madidiscuss nila yung procedure na agreed upon by them shall be valid, shall be applicable. And yung subsection C, let's proceed, subsection C, the provision in a written agreement signed by the stockholders relating to any phase of corporate affairs shall be invalidated between the parties on the ground that its effect is to make them partners among themselves. Kung may agreement between the stockholders that has the effect of making them partners, it will not be invalidated. Kasi close corporation is an incorporated partnership. They operate as partnership but the treatment of the law pa rin ay corporation. And where are we? Section D, subsection D. A written agreement among some or all of the stockholders in a closed corporation shall not be invalidated or shall be valid on the ground that it relates to the conduct of the business and affairs of the corporation, as to restrict or interfere with the discretion or powers of the board of directors, provided that such agreement shall impose on the stockholders who are parties thereto the liabilities for managerial acts imposed on the directory by this code. Yun. And subsection E, stockholders actively engaged in the management or operation of the business and affairs of a closed corporation shall be held to strict fiduciary duties to each other and among themselves. The stockholder shall be personally liable for corporate torts or wrongful acts unless the corporation has obtained reasonably adequate liability insurance. And that's all for section 99. And now let's proceed to section 100. Section 100, when a board meeting is unnecessary or improperly held. Yung as a general rule, di ba, if yung board meeting is unnecessary or improperly held, magiging hindi siya valid. Kasi nga improperly held siya. Pero sa section 100, may mga exemptions doon. Valid daw siya if before or after such action is taken, a written consent thereto is signed by all the directors. So, before na maganap yung improperly held o such actions ay may consent naman ng lahat from all the directors. So, magiging applicable or magiging valid siya. And subsection B, all the stockholders have actual or implied knowledge of the action and make no prompt objection in writing. So, dito naman, alam ng mga stockholders na yung action na yun is, alam ng mga aware ang mga stockholders about sa actions na yun, pero hindi sila nag-object through writing. So, magiging valid yung actions na yun kahit in general rule, dapat void siya. And subsection C, the directors are accustomed to take informal action with the express or implied consent of the stockholders. So yun, if sanay na yung corporation with that kind of practice sa loob ng kanilang corporation, so, ang mangyayari, magiging mano-normalize na siya. So, pwede na siyang maging valid. And letter D, all the directors have expressed or implied knowledge of the action in question, and none of them makes a prompt objection in writing. Yun, alam ng mga directors, alam nila, aware sila. Pero, wala silang objection in writing, so magiging valid pa rin yung actions na yun. So, yun lang po sa Article Republic Act number 11232.
So, Section 101, Preemptive Right Closed Corporation. The preemptive right stockholders in closed corporation shall extend to all stock to be issued, including reissuance of treasury shares, whether for money, property, or personal services, or in payment of corporate debts unless the articles of incorporation provide otherwise. So means that the preemptive right is a transfer share from corporation to the stockholders. So whatever kinds of share it is, as long as it's transferred to the corporation to stockholders. So may preemptive right ang stockholder sa closed corporation. Section related to amendment of articles of incorporation. Any amendment to the articles of incorporation which seeks to delete or remove any provision required by this title or to reduce a quorum or voting requirement stated in the set of articles of incorporation shall require the affirmative vote of at least 2/3 of the outstanding capital stock, whether with or without voting rights or of such greater proportion of shares as may be special provided in the articles of incorporation for amending or removing any of the aforesaid provision at a meeting duly called for the purpose. So remember that there must be a meeting called for the purpose. Merely consent is not sufficient, although there is allowed in section 15. So this seeks to delete or remove any provision required by this title or to reduce a quorum or voting requirement. The effect here is to terminate the status as a closed corporation. Kaya nga tanggalon ang isa or ang katong tulo. To terminate mo na siya and it will open as a public corporation. Rules and exception when board meeting are necessary. So, general rule, the directors of a corporation cannot act individually or separate in order to bind the corporation. They must act as a board at a meeting duly called for the purpose. So, they must act as a board. So, exemption, section 101, it enumerates the instances when a bond at a meeting is unnecessary or even if improperly held would be valid by the laws, however, may provide otherwise, or as stockholders may file his written objection in writing after having knowledge of the action taken by the directors. Section 103. Deadlocks notwithstanding any contrary provision in the closed corporation's articles of incorporation, bylaws, or stockholders agreement. If the directors or stockholders are so divided on the management of the corporation's business and affairs that the votes required for the corporate action cannot be obtained, with the consequences that the business and affairs of the corporation can no longer be conducted to the advantage of a stockholders generally. The commission, upon written petition by any stockholders, shall have the power to arbitrate the dispute. So, in deadlocks, remember, stockholders are so divided respecting to the management of a corporation that the votes required for any corporation action cannot be obtained. So, deadlocks or equal no majority votes to transact business. Obviously, the transaction of the business cannot be conducted because of the deadlocks. In the exercise of such power, the commission or SEC shall have authority to make appropriate orders such as first, canceling or altering any provision contained in the articles of incorporation, bylaws, or any stockholders agreement. B. Canceling, altering, or enjoining a resolution or act of the corporation or its board of directors, stockholders of officers. So, pwede nila i-cancel lang kahit na ano, resolution or palitan or pigilan ang any act of the board. So, C. Directing or prohibiting any act of corporation or its board of directors, stockholders, officer, or other person party to the action. So, direct or prohibit, pwede nila prohibit ang bali na ito as long as it will serve to break the tie para ma-resolve ang deadlock. So, D. Requiring the purchase of their fair value of shares any stockholders either by the corporation regardless of the availability of restricted retained earnings in its book or by the other stockholders. E. Appointing the provisional directors, dissolving the corporation, and importantly, granting such other relief as the circumstances may warrant. Section 104. Withdrawal of stockholder or dissolution of corporation. In addition, and without prejudice to other rights and remedies available under this title, any stockholders of a closed corporation may, for any reason, compel the corporation to purchase shares held at fair value which shall not be less than the par or issue value. When the corporation has sufficient asset in its book to cover its debt and liabilities exclusive of capital stock, provide that any stockholder of a closed corporation may be written petition to the commission compel the dissolution of such corporation whenever any or the directors, officers, or those in control of the corporation is illegal, fraudulent, dishonest, oppressive, or unfairly prejudiced to the corporation, or any stockholder, or whenever corporate assets are being misapplied or wasted. So, stockholders can withdraw from a closed corporation without any reason. If a stockholder can withdraw in a corporation, he can compel corporation to purchase his share at the fair value, which shall not less than the par value or issue value, provided that the corporation is sufficient asset in its book to cover its debts and liabilities to exclusive capital stock. So, divide or withdraw, remember, may exercise for any reason.